Welcome back to One Stop Law. Now, in our previous lecture, we have learned about, or we have been learning about the essential elements for a valid contract. We studied first about Section 10 of the Indian Contract Act, which lays down the requirements of a valid contract, but we also learned that that section is not self-sufficient, that is not an exhaustive section, and we have some other sections of the Contract Act dealing with some other essential elements as well. So in our previous lecture, we have learned about 5 essential elements, and to do a quick recapitulation, we learned about that there must be a valid offer and acceptance between two parties, resulting in a valid agreement. Then the parties must have a clear intention to enter into a legal relationship and not just a mere social or a domestic relationship. The third essential element was that the parties must be competent, they must be capable of entering into a contract, they should not be minor, lunatic, insolvent, or a convicted person. Fourth essential element was there must be a consideration between the parties, and that consideration must be a lawful one. And the fifth one was the essential requirement of a free consent, that is, the consent of the parties must be free and it should not be caused by coercion, undue influence, fraud, misrepresentation, or mistake. So in this video, we will continue with the rest of the essential elements required for a valid contract. So let's get started with this video. Next is lawful object. The object of the agreement must be lawful. In other words, it means that the object must not be anything illegal, immoral, or opposed to public policy. Okay, so if an agreement is made between two parties, say A will pay rupees 5 lakhs to B, if B goes to rob a bank, okay, or say if B goes to kill a person, okay, a contract killer type thing. So all these agreements where the object of the contract is something illegal or unethical or immoral, okay. So if someone says that if you promote gambling, I will give you this much amount of money, so this is a completely unlawful purpose for which the contract is made, and therefore all these kind of agreements where the object itself is unlawful, illegal, or immoral, the contract is void. And the next ingredient is of certainty. That is, an agreement must be certain and not vague or indefinite. That is provided under Section 29 of the Indian Contract Act. Because if the agreement is vague and it is not possible to ascertain its true meaning, that then it cannot be enforced. Just think of a situation. Suppose you go to a shop and that shopkeeper sells every kind of oil, and you go and ask him, give me 5 liters of oil. Now he sells coconut oil, he sells mustard oil, he sells refined oil, he sells olive oil. Now what will he make out of your statement that give me 5 liters of oil, which oil to give, or whether you want all kinds of oil of 5 liters each? This is not this is completely vague and uncertain, and such contracts, such agreements are void. The next essential ingredient is about possibility of performance. Like, a contract is valid only when it is possible to perform. So if the terms of the agreement are such which is not possible to perform, okay, which is not capable of giving effect to, then that agreement is void. That is, an agreement to do an impossible act is void. Now this impossibility can be, at the very beginning there are two specific sections on it, section 36 and 56. Section 36 talks about where a contract is based on some contingency, a condition is given, okay, and that condition is like impossible to be fulfilled. Like, suppose A says that I will give you rupees A says to B that I will give you rupees 500 if tomorrow sun rises from the west. So sun will never rise from the west, and this contract is impossible to perform. So this agreement is void ab initio. And section 56 talks about something which is subsequently impossible. Maybe when I made the agreement it was possible to perform, but subsequently its performance become impossible, then also that kind of agreement is void, that kind of contract is not enforceable. So say, suppose there was a contract, a school contracted an auditorium hall to organize its social or fest there, but unfortunately just 2 days before that program that auditorium caught fire, okay, and now it is impossible for the school to conduct that show there. So that way also an agreement becomes impossible to be performed, and that makes the agreement void. Now we come to the second last essential ingredient for a valid contract, and that is basically agreement not expressly declared void. Basically, the Indian Contract Act itself declares certain kinds of agreements to be void, and it prescribes those scenarios, those circumstances under various sections. Section 24 to 30 of the Indian Contract Act lays down the conditions under which agreements are expressly declared void by the Indian Contract Act itself. Suppose Section 24 says that an agreement which has an illegal object is void. An agreement which is without consideration is void under Section 25. An agreement which restrains a marriage is void under Section 26. So like this, an agreement which is in the form of a wager, that is where you are doing some kind of dating, okay, that is void under Section 30. So all these different circumstances, an agreement to restrain any kind of legal proceeding is void. So all these conditions are mentioned under Section 24 and 30, and if any agreement is made with this object which is expressly prohibited under Sections 24 to 30, that is void, and that is also not enforceable under the Indian Contract Act. Now we come to the last essential ingredient, that is some legal formalities. Now, if you know contract, you know that a contract not essentially be in writing. Okay, when we suppose board a public bus, or say we go to a restaurant to have our dinner or lunch, we don't enter into some written agreement. But there are of course certain contracts which require other formalities, like it has to be in writing, it has to be registered. Suppose two companies are merging, okay, merger of a company, okay, a company is taken over by another. Recently, say Tata Group took over this big basket, okay, so there has been a merger agreement, and this company going to that company, or any kind of company deals, okay, some major or say very important kind of contracts, they have to be, reduced to court papers, they have to be in writing, they have to be, required to be attested by a certain number of witnesses, and they have to be registered. So any contract which requires these kind of formalities, in contract 2 you have some special contracts where you have the contract of indemnity, guarantee, okay. Guarantee means someone gives a loan on credit when he sees there is a surety to ascertain that even if the principal debtor fails to pay, I have my loan secured because I have a surety for that. So a contract of guarantee is always in writing and signed. All these formalities are to be maintained. So if the contract is such which requires some special formalities to be done, then unless those formalities are done, you cannot enforce that contract, okay. So legal formalities for whichever contracts, in those scenarios if they're required, they have to be done to make that contract enforceable by law. Otherwise that remains an a void contract. That's all for this video. We learned about all the 10 essential elements of a valid contract. In our next video we will learn about some other law topic. Till then, thank you all.